sir.
The appellant would like to reserve 4 minutes for rebuttal, Your Honor.
Thank you very much. You may proceed.
Thank you, Your Honor. I'm Tyler Chastain of the Knoxville Bar. I am representing the estate of John Qeener through the personal representative Carolyn Junk. This is a matter which was tried in the Chancery Court for Knox County, Tennessee. We believe that what we're asking the court to do is essentially reverse a ruling that granted $50,033.84 related to 2 CDs, which I'll refer to as CD 89 and CD 91. The court did not afford the estate that recovery. It said that those matters were properly transmitted through a designation of beneficiary called a limited agreement to Dolores Qeener Griffin and Rebecca Griffin. Those were done in, this we'll argue, in April of 2021, right before Mr. Qeener's death. I may refer to Mr. Qeener as the decedent, and if I do that, I apologize. I just want to let the court know that. This case was tried. This case was tried over several days, and what we're here for today, Your Honor, is under the equitable standard review. We've argued, based upon numerous filings by all the parties, that the aggregate weight of this evidence supports a different finding of fact, that with a greater convincing effect, and that those $50,033.84 that judgment should be reversed, and the estate should recover that, plus its pre-judgment and post-judgment interest. Now, we also, as the estate, did receive an award of $13,255.05 related to transactions that were conducted essentially during the last 6 to 8 weeks of Mr. Qeener's life, which included a purchase by Mr. Griffith, the defendant, of a tractor of $11,133. The trial court, and the trial court had numerous findings of facts from both sides, and it was, I consider it a well-tried case by Mr. Johnson and myself. We had a lot of things go on. I believe that the facts, when you put them all back together in this little bit of time I have to argue, but you read in our brief, you'll see that the findings of fact show a greater effect that we should be receive that $50,000. How do I get there in 9 minutes, right? So we'll look at.
Let me try and shorten it,
Yes.
if I can help. It seems to me that ultimately this case kind of turns on the credibility of the bank representative, and the trial court found her to be credible. And so given that we're supposed to give great deference to those credibility determinations, how do we as a court get around that and adopt your argument?
Thank you, Your Honor, for directing us to that. Let's go to page 32 and 33 of my brief. I set out a chart of all the documents with the credit union. Those charts, and that chart shows what the address was of Mr. Qeener, the decedent. He lived at 1585 Coleman Road. And then in March of 2010, Mr. Griffith, who was assisting him, had that address changed to 11,700 Couch Mill Road. Now, Ms. Taylor testified that every document after this address was changed in the credit union database had to be printed with that new address. And that chart shows that after that date, everything in all the trial exhibits, those are trial exhibits, not my chart, that all those were printed with 11,700 Couch Mill Road, except for the documents at issue here with these CDs. They still had 1585 Coleman Road. Ms. Taylor said, I would never allow someone to print out a document and take it out of the credit union. Mr. Griffith, though, testified, and it's in the record, I believe it trial on the volume 3, 252 and 261 and 260, that he kept in his home he said 3, 4, or 5 agreements that he could take back to the credit union at any point. The importance of that is those have the address of 1585 Coleman Road. That would have been done before these 2 CDs would have ever been in existence. They were not even purchased till August of 2010 was 89, and 91 was in September of 2010. What the effect of it is, I believe that is evidence, which I believe that there's a greater weight of evidence that those documents were printed out. And Mr. Griffith did hold those, and I believe the trial court erred in the consideration of those documents, because those documents could not have been printed out anywhere near the time these CDs were even purchased in 2010. If you go by Ms. Taylor's, take her testimony, it's totally true that I could never have these documents printed out with a different address. Why the court may have found that way, he accepted her testimony, I agree, Your Honor, but I believe that when you look at the greater weight of the evidence, this is at the same time these two documents showed up at the credit union on April 28th of 2011. 17 days after the same transaction done by Mr. Griffith was found to have been violating of his agency principles by buying the tractor. And Ms. Taylor testified, but for these two agreements of April 28th, 2011, which that's their date that's on there, the monies would have been paid to the estate. These two CDs had no beneficiaries. It would have gone to the estate. Mr. Qeener was in bad health at the time. We've put that in the record. Mr. Qeener never left Breakville Nursing Home after March 30th of 2011 for any reason. He never appeared at the credit union. He did not leave there. So these documents, if they were signed somewhere outside the credit union. Ms. Taylor first said she saw him sign it, then she couldn't really remember it. I would like to say that I believe the weight of the evidence, we had so much going on in this case. I just think that those facts and those dates of those documents were somehow overlooked or misinterpreted by the court. Your Honor, I believe that's how I get around. If Mr. Taylor's testimony is true, as the court said, she would have never let him get out. But Mr. Griffith said he had them. He has said in his testimony was, I had 3, 4, or 5 of these in my white notebook. This would correspond with how these showed up with an address that could not have been printed out after April of 2010. Can I reconcile how the judge came to all of his decisions? No, I cannot. I can point to the direct evidence and the circumstantial evidence associated with those two documents. Now, the court in its review of contracts, that would do without a presumption of correctness, and we'd have to take those documents for what they say. Ms. Taylor says, well, this doesn't mean this is the April 28th date was the date that Mr. Qeener would have signed them. It's just the day she found them and processed them. And they were effective the day she got them, but we don't have that date. So we have to look at, by the rule of law, the only date that those documents could be considered received is April 28, 2011, because that's what's on there, and they were only effective 5 days later. So those were effective essentially May of 2011, a little more than 6 weeks before he passed. But for those two documents showing up, the estate would have received the money. There's no question asked about that. And I go back to the fact that if you take the whole weight of if you look at that evidence just on that chart, and you look at the difference in the addresses and what was on there, every single thing after March of 2010 went to Mr. Griffith's home at 11,700 Couch Mill Road. There was absolutely no explanation for why the documents showed a different address. And I believe, and my client believes, that is such a specific piece of evidence that the court can say this has greater convincing effect that the court missed that issue and say that this document had to be printed well before April of 2010, and it was presented by Mr. Griffith when he realized at some point that there was no beneficiary. Mr. Griffith testified in regard to the tractor, and I go back to the tractor because the court found that he violated his agency principle, that it was his impression, meaning Mr. Griffith, that he could go buy the tractor, but it was of no value. If you take that same testimony, 17 days later, it's his belief that Mr. Qeener would want Ms. Griffith, I mean his mother and his wife, and Mr. Griffith's wife, to have these CDs. There is no dispute, and I'm not going to sit here and argue that they had not been beneficiaries at some point along the way. But when these two new CDs were purchased in 2010, in September and October, there was absolutely no beneficiary designation. So they sat there from August and September 2010 with no beneficiary. And that wasn't Mr. Qeener didn't put a beneficiary on there. Mr. Griffith couldn't have done that. It's just at the last time, right as he's getting near his death, that this happened. The court record will show that on April 27th, the day before these documents are dated, there was a meeting at Breakville about Mr. Qeener's health. These things all play into it, and I think that's just the weight of the evidence. After a trial that takes some extended time with breaks, sometimes things may get overlooked, and I think this fact got overlooked. And I know we're sitting here, seems like we're arguing I feel like I was going to argue a summation with a new standard of review today. But that's really what I feel I'm doing. And I feel like that's what this court, based on the rules that we have, this is not a case, as we heard the last case about various cases, this is a case where the court takes it with the presumption of correctness as the findings of fact and looks at that as like the estate of Haynes case that I've cited in my brief about looking at the weight of the evidence and see if there's something more probably true. It's more probably true that these documents were signed by Mr. Qeener at some point prior to him moving out of the Coleman Road house, and it more probably true that Mr. Griffith, once finding out there was no beneficiaries on these 2 CDs, took them and turned them in. And was Ms. Taylor and Mr. Griffith in any conspiracy? No, I just think that's what he did, and I think that's what's more probably true here. And thank you for directing the question, but I think I've run out of my time already. So unless anybody has any questions, thank you.
May it please the court. I'm Tom Johnson of the Knoxville Bar.
Yes, sir.
I think this case illustrates the old adage of no good deed goes unpunished. Mr. Griffith's mother, Dolores, was married to Jim Griffith's father. And in early 1995, Mr. Griffith passed away, Jim Griffith's father. In November of 1995, Jim Griffith's mother, Dolores, remarried, and she remarried John Qeener. Now, in some situations in our society, some children might not have been thrilled about that, but the point of this is Jim Griffith became very close to Mr. Qeener, and there's plenty of evidence in the file about what a great relationship those families had. After Mr. and Ms. Qeener got married, they lived in Helenwood, Tennessee, in Scott County. And the Griffiths would go up there, visit. They visited one another. Mr. Qeener would visit and go to Grandparents' Day of the Griffiths' daughter. Rebecca Griffith made holiday meals for the 2 families. They got together very often, and it was a big, nice, closely knit family. In 2008, it was decided that the Qeeners needed to have some help, and so they went to assisted living at Heritage. Before they could occupy those rooms, there had to be some cleanup work done. And who did that? Rebecca Griffith and her sister. They shampooed, they painted the room. The point of all this is that after the Qeeners moved in, the Griffiths were a constant presence in the Qeeners' life. They took care of them. They bought things for them. And yes, they were reimbursed for those purchases. They bought things for them. They bought food. Eventually they needed to buy diapers and that sort of thing. They changed out their seasonal clothing. Rebecca Griffith took Mr. Qeener to the dentist, took him to most of his doctor's appointments, took him to the audiologist, took him to the VA, did all those things. And the proof showed that Rebecca and Jim Griffith visited the Qeeners once a week, twice a week, sometimes more. During that time, the Junk family, the appellant family, were pretty much absent. Very little contact, occasional. Rebecca Griffith remembered meeting one of the Qeener sons one time, and that was an occasion where Rebecca cooked for the entire family on a holiday. So in March of 2011, Mr. Qeener he got pneumonia. They had to take him to UT Hospital, and thereafter he went to Breakville. Now, we have never contended, ever, that those limited agreements dated April the 28th and May the 6th of 2011, we have never contended that they were signed on those dates. If the transcript is full of testimony about what those dates mean to the TVA people handling the account. Back office dates, just really, it doesn't sound like maybe it was the best type of practice, but that's what happened. And Jim Griffith personally was aware of some instances where financial transactions took place on a certain day, and that the date on the TVA document showed a different date. He saw that happen several times. So the date on those limited agreements doesn't mean that much in terms of when the financial transaction actually occurred. Now, Mr. Chastain missed some parts of Mr. Griffith's testimony about the little white notebook. He questioned Mr. Griffith about that notebook because in the discovery deposition, and at the end of Mr. Griffith's testimony, he ended up saying, I just don't know, or I don't remember. But at the trial, not at my urging, but upon questioning by Mr. Chastain, Mr. Griffith testified that, upon reflection, he didn't use that word, but he had power of attorney for his mother, Dolores Qeener, and that he had a white notebook when he dealt with his mother's affairs. So this wasn't a case of where, yes, indeed, there was a little white notebook. Yes, indeed, Karen Taylor sent those, pre-printed those forms and gave them to Jim Griffith. That's not the situation at all. It is certainly not established that Jim Griffith had any pre-printed forms in his possession before April of 2011. Mr. Chastain's theory today is that Jim Griffith signed those pre-printed forms April 28th and May 6th. His client testified that she thinks Karen Taylor forged her father's name and signed them. A completely different theory. The case does boil down to the credibility of Karen Taylor. And you have to remember, this case was tried over a period of time, and the events that gave rise to this lawsuit occurred in 2008, 2009, 2010, 2011. It's difficult to remember back that far, and yes, there were some inconsistencies in Karen Taylor's testimony, but some things she was not hazy about, some things she was not a little nervous about, and that is she valued her job, and she valued the relationship she had with her employer. The proof showed she was an excellent employee, that she won awards. Why in the world would Karen Taylor, who didn't know any of the parties, didn't know me, didn't know Tyler Chastain, didn't know Jim Griffith, Rebecca Griffith, John Qeener, Dolores Qeener, didn't know any of the people involved, and yet she forged, according to Ms. Junk, she forged every document that's in this court record that was allegedly signed by Mr. Qeener. Karen Taylor testified that she would never do such a thing. She was trained in elder abuse. She was satisfied that every transaction that Mr. Qeener entered into was his wishes. That was his wishes. And there were times when she would talk to Mr. Qeener, and Jim Griffith was not even in the same room. She was satisfied that these were Mr. Qeener's wishes, and she said that I personally saw every document signed by John Qeener. I personally did. Now, I don't think she would say that unless she did. There's just no explanation for why in the world Karen Taylor would risk her employment and testify falsely in a court of law if her testimony about seeing the document signed by Mr. Qeener, if her testimony wasn't correct. The proof shows that at the very beginning of this relationship, Mr. Qeener opened his account in 2008, that he let it be known that he wanted one CD to go to Rebecca Griffith and he wanted both $25,000, but one CD to Rebecca Griffith and one to his wife, Dolores Qeener. He let that be known at the beginning. During the time Mr. Qeener was alive, there were 11 CDs issued, and out of those 11, the junk children, or the Qeener children, were listed as beneficiaries on 4 of them. Dolores Qeener was listed as a beneficiary on 4 of them, and Rebecca Griffith was listed as a beneficiary on 3 of them. So from the very beginning to the very end, it was clear that it was Mr. Qeener's intent that his wife and his daughter-in-law, who even clipped his toenails, would get a $25,000 CD. Is there a timer up here? I can't say. How much time do I have left?
It's on your podium.
In front of me. I want to go to the issue of the lawnmower for a moment. We have never, ever contended that that transaction was for the benefit of John Qeener. It wasn't. Jim Griffith explained why he felt like it was appropriate to purchase that lawnmower when he did. At the time, Mr. Qeener was talking to Mr. Griffith about what he wanted to do with his CDs. He said that I want to give all 3 of you a $25,000 CD. And Mr. Griffith said, no, I don't need that, John. I don't need that. And he talked Mr. Qeener out of doing that. But he did tell Mr. Qeener, if at any time I ever feel like I need a little help, I might call on you. I might let you do that. Well, on a hot day, this lawnmower blew up, locked up. His mother called about that same time, got him out of the lawn, something she needed him to do for Mr. Qeener, and he just decided that I'm going to take Mr. Qeener up on his offer, and he did. Now, with respect to the checks that the chancellor ruled against Mr. Griffith on, several of them had odd amounts. They were clearly, I think, for reimbursement items. And for some reason, the chancellor lumped those together with a couple of other checks and held that they were intended for the care of the Qeeners. We don't think that was what most of those checks was for. Now, and Ms. Junk testified that the reason she didn't agree with those checks is because there were no receipts. Well, Mr. Griffith wrote over 100 checks during the time, and there were lots of reimbursements. And it's not surprising that there was a check missing or receipt missing. A lot of this case depends on Jim Griffith's testimony as well and his credibility. This man who supposedly signed Mr. Qeener's name to those limited agreements and who tried to rip off Mr. Qeener's children by spending money that he shouldn't have, he received a check after Mr. Qeener died. The check was from Breakville Nursing Home of about roughly $2,800. And no one knew that check was sent to Jim Griffith. It wasn't Jim Griffith's money. It was money that was actually Mr. Qeener's money. He could have easily pocketed that money, and no one would have been the wiser. But he didn't do that. He turned that money into where it should have been turned in, and that is to the estate. The only surprising thing about Chancellor Weaver's decision, or about the situation, not his decision really, but about the allocation of 2 CDs, one to Dolores Qeener and one to Rebecca Griffith, the only surprising thing is that they didn't get more, considering how much the Griffiths did for Mr. Qeener. And the obituary, I think, is in the court record where it was noted how good they were. So we think the chancellor correctly weighed the evidence, and we ask that this case be upheld on appeal insofar as the CDs are concerned. And we would ask that it be reversed with respect to the checks on the lawnmower and the other checks. Thank you.
Thank you, sir. Yes, sir, your rebuttal.
Yes, just briefly, Your Honor. Your Honor, when we talk about what Ms. Taylor did or didn't do, we have to look at her testimony and what we've cited succinctly from the record. Ms. Taylor testified in trial volume 3, pages 361 to 364, that she did not know when the agreements were signed. She's testified in volume 2, pages 141 and 144, that she does not remember exactly where Mr. Qeener would have signed these documents. At one point, she says I may have seen him sign them in the parking lot. All we know for this case is, and that reference was on page 130, about he may have signed them in the parking lot. What we do know is that she put initial on there, but for those two documents, document 89 and 91, which are trial exhibits 6 and 7, all those monies would have been paid to the estate. Mr. Griffith can give us various different stories about the white notebook, but as we pointed out when we first took his deposition and read it in the record as well, and we asked him about it, he said he kept 3 or 4 or 5 TVA membership limited agreements pre-signed by the decedent if he needed to have them signed and delivered to the credit union. That's what he testified to. Those agreements, if you take his testimony, he had them pre-signed so he could deliver them. They were delivered, and that changed the 2 CDs in this case. Those 2 CDs were paid to 2 beneficiaries named by law and by the interpretation of those contracts no earlier than April 28, 2011, when they were received by the credit union. The credit union says they're effective 5 days later. Absent those 2 agreements, those monies would have been paid to the estate. We pointed out in the record that we believe that it doesn't matter if Mr. Griffith was benevolent. It doesn't matter about any of those things. And what matters is how did those 2 documents get there? And we believe the testimony and the greater weight of the effect of this testimony, when you look at the direct and circumstantial evidence associated with those 2 agreements, Mr. Qeener could not have gone to the credit union and signed that. There is undisputed that he never left the nursing home after he got there on March 30th, 2011. Never left. Had severe cognitive impairment at that time as well. He could not have made a decision. In fact, Chancellor Weaver found that Mr. Griffith's impression or determination that he could even buy the tractor violated agency principles. To decide anybody should have a CD after those dates would also violate the same agency principles. Unless your honors have any questions, I appreciate your opportunity to argue today.
I hear none. Thank you.
Thank you, Your Honor.
I want to thank both of the attorneys for your presentation. Your case has now been submitted to this court.